So, hello everyone. My name is Sarah, and I am with the Shelter Island Public Library. I'm here with Terry Lucas from the Shelter Island Public Library and Mara Zonderman from the Westhampton Free Library. We are back with talking about the Bill of Rights, and we'll be discussing the Fifth Amendment today. First, I have a few of our East End public libraries that we'd like to give a thanks to for joining us on this. Big thanks to the Westhampton Free Library, Amagansett, Cutchogue, New Suffolk, East Hampton, Floyd Memorial, Patchogue Laurel, New Suffolk Public Library, Quogue Public Library, Southold, Port Jefferson, and Riverhead Public Library. Additionally, I will be sharing the playlist of all of the Bill of Rights so far that we've discussed. We have a YouTube playlist already set up for that, so I will pop that into the chat, and then that will also get emailed out with the recording after this program. So I'm going to pass it along to Mara, and we will be all set. All right, thanks so much.
Thanks, Sarah.
Okay, thank you, Sarah. Okay, welcome back. On tonight, tonight's docket, we have the Fifth Amendment, um, which goes as follows. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the military, or in the militia, excuse me. When, sorry, my window's in the way here. Make it stop. There. When in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That's a lot.
That's a
So
lot.
that's a lot. But we can break it down pretty clearly into five distinct clauses, as you can see with the color coding there. So hopefully that will make it a little more digestible. And we are going to start off at the top. Grand juries. Terry, tell us about the grand jury requirement.
Okay, so again, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in times of war or public danger. So, this clause was derived from the Magna Carta, which was signed in 1215. Next slide, I believe. And while other parts of the Fifth Amendment were incorporated by the Supreme Court, applying the Due Process Clause of the 14th Amendment, the right to grand jury was not incorporated. Despite this, all but two states, Pennsylvania and Connecticut, have a form of grand jury. And I know that Mara is going to talk about that a bit more. So, early British common law, dating back to the 12th century, provided for a grand jury to protect the accused from prosecutions by the monarchy. Prior to that time, innocence or guilt was determined by subjecting the accused to trial by ordeal. This is our next slide. That's often by binding the accused and throwing them in the water, or subjecting them to fire. And if you floated, you were guilty. If you sank, you were considered not guilty, but then you would probably drown. It's like the old witch trials we learned about back in fourth or fifth grade there. Trial by fire, they would just make you carry around a very hot iron and then watch for 3 days to see if you healed well. And if you healed well, you were not guilty, but if you got an infection or something, you were considered guilty. So it's not the best way to determine innocence or guilt. So the next slide, later on, under the procedure called for by the, I don't know how to exactly pronounce this, Assize of Clarendon, proposed by Henry II in 1166, 12 good and lawful men from each village were assembled to announce the names of those suspected of crimes, probably about once or twice a year. And this was the first step towards trials run in an evidentiary model. Evidence was made by the layman, by knights, or by freemen under oath. The suspected criminals were then presented before the royal justices, and based on the evidence presented, their guilt or innocence was determined, and it was deemed to be by judgment of God at that point. So, when the Constitution was being written, the founding fathers decided to keep the grand jury system as a protection against unfair prosecution by the central government. Again, there's always that concern about this strong central government. In 1683, as this picture shows, the grand jury system was noted in the Charter of Liberties and Privileges, which was passed by the first elected assembly in the colony of New York. This right was included in James Madison's first draft of the Bill of Rights, and there's really no record at all of debate or opposition. It seemed to be taken as a given. Grand jurors were selected from the body of the people. Their work was not hampered by rigid procedure or evidentiary rules. Grand juries could act on their own knowledge and were free to make their presentments or indictments on such information as they thought was satisfactory. And the grand jury was to act in secret and to act free of prejudice or favoritism. And the Fifth Amendment allowed the accused to challenge a grand juror on the grounds of bias or partiality. So grand juries are able to investigate the crimes of the accused, but may not hire government officials to do that. So all of that kind of plays into, once again, protecting against people of having too much power. So at this point, I'm turning over this clause to Mara to tell you about a little bit more about the grand jury.
Okay, thank you. So the grand jury is one of the few clauses in the Constitution that's actually fairly straightforward. It's the courts have interpreted it to sort of mean what it says. But the question that does arise is, what is a capital or otherwise infamous crime? And the courts have said that that determination relies on what is the maximum possible penalty if someone is found guilty. And the line has been drawn at crimes that are punishable by imprisonment or hard labor are sufficient to render a crime infamous, and so trigger the grand jury clause. So basically, if you're going to be sent to jail, you have the right to have your evidence presented before a grand jury before trial. If the conduct is punishable of a fine of less than $1,000 or imprisonment for not more than 6 months, you may be tried without having that sort of pre-trial grand jury procedure. So, there's a fairly bright line there. So the question that comes up is what makes a grand jury different from a trial jury? Made a little chart. So part of it is the burden of proof. A grand jury is only asked to look at the evidence presented by the prosecutor. The prosecutor is the only person to present. The defense does not present because it's just the government's opportunity to say, we think we have a case, but is there enough here to proceed to bring charges? And this is where I basically, point out to anybody who's ever watched an episode of Law and Order, that you've seen some of this before. Or at least they talk about, is it enough to bring to a grand jury? They bring it to a grand jury. The grand jury says, yes, there's a reasonable basis for to bring these charges. Once you get to the trial jury or the petite jury, literally a big jury and a small jury, then the standard of proof is beyond a reasonable doubt, as we're familiar with, but that we're nowhere near that at a grand jury. What is the effect of the decision? A grand jury, the effect is the prosecution can proceed with charges or not. The grand jury can come down and say, yeah, no, we don't see it. And then the prosecution has the opportunity to come back with more evidence, different evidence, but that's the role of the grand jury, whereas the trial jury is actually going to be finding the defendant guilty or innocent. The rules of evidence are slightly more relaxed, actually more than slightly. And you hear talk about hearsay all the time. Hearsay is pretty much okay in a grand jury. Someone told me this and I'm now telling you. A trial jury would not be allowed to hear that. That would be an objection. Grand jury, you can hear it. We talked about search and seizure. And even if there was no warrant, often that will be allowed to be put before the grand jury as they make their decision about proof. Although, if the case rests solely on some illegally gotten evidence, that may provide a problem. But it's not a problem in terms of showing it to the grand jury. And then unanimity. So a grand jury is usually 12 to 23 citizens, and only 12 of them, or excuse me, 16 to 23 citizens, only 12 of whom need to vote in the affirmative. Whereas a guilty verdict by a trial jury has to be unanimous. So there's no requirement for unanimity, just depending on the size of the jury, either just over half or a greater majority. So one thing that is interesting about the grand jury is that it does not apply in state courts. Although, as Terry said, 48 of the 50 states do have grand juries, and New York is one of them. But we talk a lot about how the Bill of Rights was incorporated to apply to the states through the 14th Amendment. Most of it was. This clause is, in fact, the only criminal procedure protection that's in the Bill of Rights that hasn't been found to apply to the states. And the reasoning is that a grand jury isn't a prerequisite for the satisfaction of due process. The court, way back in 1884, said, "We are unable to say that the substitution for presentment or indictment by a grand jury of the proceeding by information after examination and commitment by a magistrate, certifying the probable guilt of the defendant with the right on his part to the aid of counsel and to the cross-examination of the witnesses produced for the prosecution, is not due process of law." In plain English, what that means is, as long as there is something, and oftentimes the something is simply the prosecution going before a judge in a much more informal proceeding than a real trial, and a judge plays the role of a grand jury. The court has said that's okay. Due process is satisfied as long as there is something. It does not have to be a full grand jury. And so that's, like I said, not much to interpret about the grand jury. We do have it in state courts. Anybody who gets charged with a federal crime obviously would have the right to it, but I think we can move on to the next clause.
That sounds good.
All right.
Okay,
I
clause
couldn't
number 2,
resist.
double jeopardy. So it reads, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." So this clause is meant to protect citizens from repeated accusations of the same crime and is commonly known as double jeopardy. And when you go and you're Googling around and doing your research, you get so many cool images of good double jeopardy questions. But then you turn it back to double jeopardy and the Constitution and the Bill of Rights. So the concept of double jeopardy is ancient. It appeared in cases in ancient Greece and in Rome. Its origin is unclear, yet in the ancient documents, it seems to be taken as a truth. In ancient Greece in 355 BC, Athenian statesman Demosthenes, I cannot say that name, said, "The law forbids the same man to be tried twice on the same issue." In Rome, the prohibition against double jeopardy was codified in the Digest of Justinian, which stated no one ought to be punished twice for the same offense. So basically said the same thing. The next slide. In English common law, it was a universal maxim that a man could not be tried for the same crime twice. It was just kind of taken as a given. And it may be that it just makes sense, honestly. It was cited by eminent judges starting in 1250 and on to Sir William Blackstone, who's often cited in English law. You're always going to hear about Sir William Blackstone, who in 1769 wrote in his treatise on law about double jeopardy. Despite the fact that prohibition against double jeopardy was a given, it was very narrowly construed at this point. It only applied to crimes that were punishable by death and only after an acquittal or conviction. If the trial ended without a conviction or acquittal, the person could be tried again. So we move on to the new colonies. The common law rule was applied in different ways, in different locations. In some cases, when the trial didn't end with an acquittal or conviction, a new trial was still barred. In others, a new trial was allowed. So it wasn't quite as clear in the colonies. The first Bill of Rights that adopted the double jeopardy clause was the New Hampshire Constitution of 1784. New Hampshire had been the first to enact a constitution even before the Declaration of Independence, and they modified it as they went along. One of their later versions, the 1784 version, said, "No subject shall be liable to be tried after an acquittal for the same crime or offense." Pretty simple. So when Madison introduced the clause of the Fifth Amendment, it read, "No person shall be subject, except in cases of impeachment, to more than one punishment or trial for the same offense." This clause was actually heavily debated in the House of Representatives, but in the end, the existing language was approved by the Senate and accepted by the House, and that is where we went. The language that was approved followed the language of the previously mentioned Blackstone and only changed by adding limb, which kept it from being applicable only to capital cases. So throwing the limb in there made its application wider. According to Professor George Thomas from Rutgers Law School, the framers wanted, again, to limit the power of the federal government. He said, "One way a corrupt state could attack its enemies would be to keep prosecuting them even after acquittal. The framers wanted to make sure that central government could not do that." And with that, we'll turn it over to Mara.
Okay. And my slides got a little out of order. Oh, good, that worked. Okay, so here we are, back to double jeopardy. Okay, so the court's clearest statement as to what the double jeopardy clause means was given by Justice Black in a 1957 case. He said, "The underlying idea is that the state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity." So he's understanding that this is meant to be a check on the power of the state or federal government, and I do mean either, because this clause has been incorporated to apply to the states since 1969. And since the 1970s, jurisprudence on double jeopardy has been sort of a muddle of technicalities. But if your basic understanding is that you can't be retried for the same crime once you've been acquitted by a trial court, you're not wrong. However, if a conviction is overturned on appeal, you can be tried again in the lower court if the appeals court overturned due to a procedural consideration and not because of an insufficiency of evidence. And if you think that's complicated, now you know what I mean when I say a muddle of technicalities. But basically, as long as the appeals court does not say there was not enough evidence for a guilty verdict, they just say something went wrong in the trial itself, you can be tried again. One of the other questions then is, what is considered the same offense? What does that mean? And the court applies what they call the Blockberger test, all the way back from a case in 1932. And they say, where the same act or transaction constitutes a violation of two distinct statutory provisions, the test to be applied to determine whether there are two offenses or only one is whether each provision requires proof of an additional fact, which the other does not. And the sort of clearest example that I could find of this came from a later case from 1958 called Gore v. United States, and it involved a drug sale. there were three separate charges arising from a single drug sale. So there was one transaction, three separate charges. The sale violated the law against requiring a prescription for the sale of narcotics. The drugs were not in the original stamped package or from the original stamped package. And also, it was done in secret, so it violated the provision about facilitating concealment and sale of the drugs with knowledge that the drugs had been unlawfully imported. And in this case, and in most double jeopardy cases, the court looks to legislative intent pretty clearly. Did the Congress or the state legislature intend to establish separate crimes? Or did they just try to make different levels of crimes? And in this case, the court said Congress had made three distinct offenses in connection with the vending of illicit drugs, and the petitioner, having violated these three independent provisions, was prosecuted for all three as separate wrongdoings, despite the fact that these violations of what Congress had prescribed were compendiously committed in single transactions of vending. Somebody's making funny faces at me. Can you guess who it is? Hi, Ari. It's my older son. More plainly, stop that. If each crime requires proof of at least one element that the other crime does not, then they are considered separate offenses, and the court can compose separate sentences for each one. So in this case, one required evidence as to the fact that there was no prescription. Another charge required proof that the drugs were sold not in their original packaging. And the third required proof of concealment and knowledge of the unlawfulness of the transaction. Three separate pieces of things that needed to be proved. And in this case, the court was looking at three charges brought together on a same trial. Theoretically, it doesn't make a ton of sense since we're dealing with a single act, but the court could say, the prosecution could bring one charge and see if it stuck. No, okay, we'll try this one. But in this case, they brought all three together, and they got guilty verdicts for all of them altogether. Another important thing to think about when we're talking about double jeopardy is this question of whether the same crime can be prosecuted at the state and federal level. And the answer is yes. It's known as the dual sovereignty position. And the court says, we have here two sovereignties. The state is one, the federal government is the other, deriving power from different sources, capable of dealing with the same subject matter within the same territory. Each government, in determining what shall be an offense against its peace and dignity, is exercising its own sovereignty, not that of the other. And one fairly well-known example comes from the Rodney King case that I'm sure most of us remember, in which Los Angeles police officers were prosecuted for the beating of Rodney King and separately convicted of federal civil rights violations after having been acquitted in state court of charges coming out of the same incident. In such situations, the court's theory has been that a defendant is not being prosecuted twice for the same offense, but rather for separate offenses against the peace and dignity of both sovereigns, and thus may be punished by both sovereigns. It prevents, for instance, a state from barring federal civil rights charges through mismanagement of a case, one assumes negligently and not on purpose. Because typically a state court will go first, and if that case was mismanaged at the state level and the federal government was then barred from pursuing prosecution, that could prove a problem. And the same thing applies if more than one state might have jurisdiction. For example, if somebody steals a car in Tennessee, drives it to Kentucky or any one of the other states surrounding Tennessee, the federal government is involved because the crime has crossed state lines. But Tennessee and Kentucky both also have jurisdiction as the place where the crime originated and the crime ended or continued. And charges could be brought in Tennessee, Kentucky, and at the federal level, because each sovereign has the right to determine their own course of justice. And double jeopardy would not apply. So the moral of the story is if you're going to steal a car, don't drive it across state lines.
There you go.
And if you're going to steal a car, don't tell anybody that you did it. But if you do, you're protected against self-incrimination.
Which is my cue.
Yes.
So the next clause is, nor shall be compelled in any criminal case to be a witness against himself. So the idea behind this clause, sometimes referred to as taking the fifth, is that the government has the responsibility to prove a person is guilty as opposed to requiring individuals to prove that they are innocent. And I think I stole your slide here and put it to the top of mine, so you'll have to take it back.
That's quite all right.
I like that. I like the kitten. So where'd this come from? At one point, there were two different competing systems of law in England. And again, we always hearken back to England for our law. In the accusatorial system, an accusation was made, and the truth of the accusation was determined by examination of others, and early on, examination of the supposed wrongdoer. The inquisitional system developed in ecclesiastical courts, and the alleged criminal was forced to take an oath to tell the truth about anything presented to him. These courts dealt with important cases like corruption, public disorder, but the accused was never informed of any charges or whether he was actually even accused of a crime or anything about the type of questions that were going to be asked. But an oath taking was taken very seriously. Oath taking is still taken seriously, but in England in those days, in an ecclesiastical court, if you took an oath, you told the truth. This could result in arbitrary decisions that could be used to oppress those that were accused of the crime, but depending on the way questions were asked and the way they were answered, because no one was actually prepared to face them. So next slide. So you may have heard of the Star Chamber, which was, and if you look here on this picture, there is a star on the ceiling, and that's why it was chamber, which I never knew until today. Needing to go in would just stare at the star on the ceiling. It was established in 1487, and it is the quintessential example of an inquisitional system. Nathan Dorn gave this description of the Star Chamber on the Library of Congress website. Imagine a court that could force you to incriminate yourself. It might go about its work like this. You are made to stand before a judge who refuses to give you any details about the charge laid against you. You are forced to take an oath before your God to answer truthfully any questions that might be put to you, and questions on any topic at all. And you are warned that refusing to answer these questions for any reason will be viewed as contempt of court, for which you may be imprisoned, lashed, or tortured as it pleases the judge. So this was a lose-lose situation. The Star Chamber was came to be dreaded and disliked because it was secretive and it was corrupt. Finally abolished in 1641, so it was around for a while. So over a period of time, it kind of became ingrained in English common law that a person could not be required to accuse himself of a crime. As would make sense, much of the law of our new country came from English common law. But while adopting much of the law, the framers of the Constitution, again, were so wary of a government that had too much power. And they did not want to have a government that could bring people to court and force them to testify. So this clause in the Fifth Amendment was born, which is the next slide. And following the revolution, 6 states paved the way by including the privilege against self-incrimination on their constitutions as well. So on June 8, 1789, James Madison proposed a constitutional provision that an individual shall not be compelled to be a witness against himself. Congress later added in any criminal case, meaning that the provision will be allowed only in criminal trials, not civil ones. This was one of the Fifth Amendment clauses providing safeguards against the abuse of criminal laws. And I really want to talk about you have the right to remain silent in the Miranda laws, but that's Mara's turn. So, Mara.
We'll get there. So the most basic understanding of what this means, as we know, is that a defendant in a criminal case cannot be compelled to testify. More to the point, choosing not to testify cannot lead to consequences. The judge can't say either testify or you're in contempt of court, which usually results in imprisonment. You can do that without fear of punishment. And the Supreme Court, it's taken a pretty broad approach to when and where and how that applies. So, for example, in 1965, the court struck down a California rule of evidence that allowed a jury in a criminal case to consider as evidence of guilt the defendant's failure to testify. So, in other words, California law at the time said if you plead the fifth, the jury could consider that as almost an admission of the crime itself. The Supreme Court said, no, I don't know. I mean, you can't legislate or litigate that. I mean, a jury is going to think what a jury is going to think, but a jury is instructed if a witness pleads the fifth that they can't consider it. I don't know how they do that, having never served on a jury. I think that's kind of impossible, but be that as it may. But the point is that it implies that the true purpose of the Fifth Amendment privilege is not only to protect a criminal defendant from compelled self-incrimination, but also to ensure that no one is made worse off by asserting the fifth than by not asserting it. So it goes along with that idea that if you choose to plead the fifth, there's no negative consequences that attach to you because of it. A few years later, in 1968, the court found that a New York City police officer couldn't be penalized for pleading the Fifth Amendment, even in a grand jury proceeding that was investigating police corruption. So it applied not just in a trial jury, it applied before a grand jury. And it's generally also considered to be a protection against incriminating oneself in any present or potential future case, which is why the right can be asserted not just by the defendant in a criminal case, but by any witness testifying in any kind of trial, criminal or civil, or in front of a grand jury, as we said, or a legislative hearing, or other government proceeding. We even see it in front of Congress. However, a government can defeat the privilege as it applies to witnesses other than the defendant and compel testimony under threat of contempt by offering immunity. So we do, again, law and order. We do see that. I can't testify to this because it will get me in trouble. But if you give me immunity, I'll get up on the stand and tell you what I know, because then the prosecution cannot use anything that is said against the witness because they are immune from prosecution. Unless they lie. Perjury is a separate example. But what do we really think about when we talk about self-incrimination? As Terry said, it's your Miranda rights. We're probably all familiar with them. You have the right to remain silent. Any statement you say can and will be used against you in a court of law. You have the right to an attorney to be present during questioning, including the right to a court-appointed attorney if you cannot afford one. And then at the end, as you see on the graphic, do you understand the rights that I have just read to you is not always actually included. And with these rights in mind, do you wish to speak to me? And that is a very important point because you have these rights, but you don't have to exercise them. You can be arrested, read your Miranda rights, and say, that's okay, I'm going to talk to you anyway. Once you do that, you've waived your rights. You no longer, you still have you can still plead the fifth, but you no longer can say, no, what I said, they coerced it. I didn't have my lawyer there. It was your choice at that point. But one of the interesting things, and once So once Miranda rights have been waived, most courts will consider anything said after that to be voluntary. But one of the interesting things about Miranda is that it's exclusionary. It's a rare case where the specific intent is to prevent something from happening. Um, and the court has said, unless and until such warnings and waiver are demonstrated by the prosecution at trial, no evidence obtained as a result of interrogation can be used against the defendant at trial. So not only do the police have to read you your Miranda rights, but then at trial, if there's going to be anything, if you say something, the prosecution then has to prove that you were read your Miranda rights and that you waived them, and that it was all, proper and above board, and all that. In recent years, the Miranda rights have become somewhat weaker than they were in the past. And there's some controversy about whether they are themselves constitutional, since the Supreme Court kind of just made them up. But they are still in effect in, I think, every jurisdiction. So if you aren't read your Miranda rights, you can hopefully not go to jail. And it's one of those things, it's with the Miranda rights that they've become so much a part of the expectations of our culture, mostly from watching crime dramas, that I don't, and this is just me, I don't think that the court could say that they don't need to be said. Right? On the one hand, we all know them. You have these rights. So they're there. The right to remain silent, the right to an attorney. It's like when they stopped asking asking at airports if you had any, I don't even remember the exact language but it was, they always asked, do you have anything, any explosive, any guns or whatever? And they stopped asking that at the ticket counter. And I remember saying to my parents, but how are people going to know that they're not supposed to do that? Right. And it just had become so ingrained in culture that they didn't feel the need to recognize it anymore. So I think this is a similar thing where the Miranda rights, even if there's a major shift, it would, at the very least, our culture would have to change dramatically before they went away. So, which brings us to due process.
Nor be deprived of life, liberty, or property without the due process of law. Without due process of law, not the. So in 1950, the Supreme Court said, it is now the settled doctrine of this court that the Due Process Clause embodies a system of rights based on moral principles so deeply embedded in the traditions and feelings of our people as to be deemed fundamental to a civilized society as conceived by our whole history. Due process is that which comports with the deepest notions of what is fair and right and just. So on the next slide, I know it's a big surprise, but we're going to look at the Magna Carta again. I'm going to see how many pictures of the Magna Carta we can get throughout this whole series. In 1215, King John stated in the Magna Carta that no free man would be deprived of his life, liberty, or property except by lawful judgment of his peers or by the law of the land. The phrase due process of law appeared later in the 1354 statutory version of the Magna Carta. It read, no man of what state or condition he be shall be put out of his lands or tenements, nor taken, nor disinherited, nor put to death, without he be brought to answer by due process of law. So the law of the land and the due process of law became kind of the same thing. So the next slide. At the time the Bill of Rights was written, the framers would have relied on the statements of Sir Edward Coke. He was the author of the Laws of England, which probably was read by Adams, Jefferson, and Madison in their early days. And he reinterpreted a lot of the Magna Carta. So these laws that he wrote about set out an interpretation of the common law. Jefferson would write to Madison later of Coke, a sounder Whig never wrote, nor of a profounder learning in the orthodox doctrines of the British Constitution or in what were called English liberties. So even while we were trying to get away from the power of England, the English laws were the laws that made the most sense to our framers. And so this is kind of where some of this came from. So in his writings, Coke talked about both procedural and substantive due process. And again, the framers would have consulted his treatise, especially when concerned with protecting accused persons from a powerful government. And Mara's going to talk about more than this, but this may also answer one of the questions that's in the Q&A right now about whether there's a limitation on what kind of laws the federal government can make. So just briefly, and Mara will go into it more, but procedural due process gives all the parties in a trial the right to be heard, provide for a specific process, and provides for a judgment by a neutral decision maker. Substantive due process protects certain liberty interests that statutes and regulations must not infringe, demonstrating that the government's deprivation of a person's life, liberty, or property is justified by a sufficient purpose. These two interpretations have made this law or this clause a pickle. So I'm turning the pickle over to Mara. Sorry.
I do not like pickles, but I'll take those.
Okay.
So as Terry said, there are two processes divided up into two things. There's procedural due process, which refers generally to the idea that decision making by the courts and the executive must be exercised fairly, and asks whether the government has followed proper procedures when it acts to take away life, liberty, or property. In a court setting, since that's mostly what we're talking about, violations of procedural due process include a failure to disclose exculpatory evidence, a judge being biased in favor or against any party, a defendant being denied their opportunity to be heard, and that includes being given notice of a hearing. Those are just some examples, but you see that they, as we say here, it's right in the name. It's part of the procedure. And you have the right to have all the boxes checked off. Substantive due process refers, in one interpretation, to those rights that are deeply rooted in U.S. history and tradition, viewed in light of evolving social norms. That's where the pickle comes in.
Mm.
And procedural or substantive due process asks whether the government's deprivation of life, liberty, or property is justified by a sufficient purpose, as Terry mentioned. What are some examples of things that are covered by substantive due process? Your right to privacy, right? Nowhere in the Constitution does it say a right to privacy, but the court has had, not sure what tense to use for this one, has said that looking at different parts of the Constitution and looking at our society as a whole, it is understood that citizens have a right to privacy. Don't ask me today what it means, but as part of our substantive due process, we have a right to privacy, including the court there's like a whole subset of right to privacy cases dealing with privacy in one's contraceptive choices, but that counts too. You have the right to marry the person of your choice, whether that person is the same skin color as you, the same gender as you. It is your right to marry the person of your choice. You have the right to refuse medical treatment, right? The idea is that it's not up to the government, federal or state, to tell you, that you must get a certain kind of treatment. One last example is that you have the right to direct the upbringing of your own children, which is also a big part of that pickle, especially these days. But if the government is going to come in and say, for example, you are an unfit parent, there's very strict things that they have to prove because you have this due process right to determine the upbringing of your own children. As you can see from these examples and from the very definition of substantive due process, it's far from a concrete concept. In fact, here in our very nerdy legal household, one of our favorite law professors is Erwin Chemerinsky out of Berkeley. And he had a great quote. There is no concept in American law that is more elusive than substantive due process. And I am not going to let Nola talk us into this, but we really could do a whole nother series of webinars just about that. But that gives you the idea of what we're talking about, and the idea that those types of rights can't be infringed because they are protected in the Fifth and the 14th Amendments. Bringing us to the very last part, takings.
Nor shall private property be taken for public use without just compensation. I don't know why this feels like a weak ending to this particular part of the Bill of Rights, but it just seems like they just kind of threw it in there, but maybe not. So this final segment provides that while government may have a constitutional right to take private property for public purposes, it must give financial compensation to the owner. So once again, it's back to the Magna Carta. Yet another picture. Yes, it's another image of the Magna Carta. This is the last time tonight, I promise. Chapter 28 of the 1215 Magna Carta provided no constable or other of our bailiffs shall take corn or other chattels of any man without immediate payment unless the seller voluntarily consents to postponement of payment. In the 16th century, Parliament made it the norm to give compensation when property was taken for bridges and roads and other public improvements. The next slide. We're going back to our friend William Blackstone. In his commentaries on the laws of England, he acknowledged the acquisition of property for public good. We need roads, we need bridges. There are certain times we need public buildings. So in order to do that, that has to come from somewhere. So you need to acquire property for public good sometimes. But he said, how does it interpose and compel, not by absolutely stripping the subject of his property in an arbitrary manner, but by giving him a full indemnification and equivalent for the injury thereby sustained. So this became, ingrained in common law of England and made its way across the pond. So in colonial times in America, just compensation for property taking was usually considered the norm. Aside from the usually public improvements, there were also mill acts, which, because so many people were building mills, mill owners had to build dams and flood neighboring lands, but they could do that as long as they paid the owners. So prior to the Revolution, when the states were developing constitutions, the idea of fair compensation for land appropriation was often included. So it was not a surprise when the Takings Clause found its way into the Bill of Rights. And as always, the concern with protecting citizens from government power weighed on the minds of the framers. The Anti-Federalists were concerned about a strong central government regulating anything having to do with economic activity. And James Madison always kept in mind when writing the Bill of Rights that it was necessary to erect strong safeguards for rights, especially property rights. So maybe this, to me, did not seem the strongest point of this amendment, but back in the day, it was very important. And we'll turn it over to Mara for the last little bit.
Okay. So takings. The clearest statement from the court came from a case in 1960. The Fifth Amendment's guarantee that private property shall not be taken for public use without just compensation was designed to bar government from forcing some people alone to bear public burdens, which, in all fairness and justice, should be borne by the public as a whole. And as a side note, I want to say, so we often hear about eminent domain. That's what we're talking about here. Same thing. And for those of you who are local, there is going to be an eminent domain hearing next week. And hopefully, maybe, my co-counsel in the other room, who pointed this out to me, will either come and tell us a little bit about it, or will send me some information so that I can share with you. But it just seemed very propitious. Oh, here he comes. That, we're talking about this and we have the opportunity to see it in action. Are you going to tell us, or no? He's going to let me know. So I'll keep going, and he'll give me some information. But when does the takings clause or eminent domain apply? It applies fairly broadly to all levels of government, so it has been incorporated to apply to the states and local governments. It applies to the taking of all or any private property, not just land. It applies to the taking of easements, to trade secrets, contract rights, and intellectual property. So if the government seizes a patent for whatever reason they have, that too falls under this clause and requires just compensation. It applies to physical takings, where the government occupies or acquires actual property. It also applies to regulatory takings, where government restrictions limit property use so severely that it becomes the equivalent of having it physically taken away from you. It applies to permanent takings. I kind of feel like I'm in green eggs and ham right now. It also applies to temporary takings. So Terry gave us the example of land that is flooded. So one example there is the government builds a dam, and it results in temporary or intermittent flooding. Even that requires just compensation to be paid to the landowner. It also applies whether the government is taking for itself or for someone else. The government can seize property to give, just don't ask me why, I'm sure there are examples, but Aquila, I don't remember the specifics of that case. He's going to tell me something else too. But either way, even if the government is not going to be keeping the property, they have to provide just compensation. What can't the government do under the takings clause? It can't take property if it's not for a public purpose. And the example there, the court, they look at public purpose, they give it a fairly broad definition. In a 2005 case, the court said that it was a public purpose for the land to be seized and then given to a private developer in the interests of economic development. So that, but it has to be a public purpose. The other thing that the government is not required to do in this case is to provide just compensation when the laws or regulations are requiring that a private property owner do some remedial work. So you've been polluting, you need to remediate your pollution or lessen your pollution. Yes, that's a government regulation, but no, we are not going to pay you to do it. That's not covered under the takings clause. The other big question, of course, is what is just compensation, right? The general idea is that the government has to give the property owner fair market value as determined by what a willing buyer would pay a willing seller. And the idea is to leave the property owner in as positive a position as if the property had not been taken. And the focus is on what the property owner has lost, not what the government has gained. And in most instances, it is usually, I mean, probably not cash, it's probably a check, but or direct deposit these days. But just compensation can take the form of some reciprocal benefit given to a party. So for example, in the case of building a road through your property, the just compensation can be an increase in the value of the land on either side. So we're not paying you specifically for that piece of property that the road goes on, but we're going to make the rest of your property worth more. Um, and there we have the Fifth Amendment. I do want to just tell you, so the hearing coming up on Wednesday, the town of Southampton is seeking to take a sliver of property from homeowners along Dune Road on the ocean side for flood control. There will be a hearing to allow owners and town residents to voice their views on this. The hearing is part of the process to establish what the price of this sliver of road is, how much the property owners have to be compensated in this case. Yes. They're what? They're taking it. Oh, not the road, the beach. They're taking it from the beach. Excuse me.
Oh.
Good thing I have a fact check.
Mhm.
And I believe that hearing can be watched on YouTube on Wednesday. And the details are on the town website.
Interesting.
Yeah. So that is the Fifth Amendment.
You know what? I was thinking that I remember 100 years ago in law school, one of the things I found really interesting about property law is even though property is property, people get emotional about it. And you go to take some land that's been in the family for hundreds of years, or you go to take something that means something to somebody, or you go to take some beach when you've spent millions of dollars to have a beachfront property. It's hard to quantify. So it's yet another pickle here. So that's the Fifth Amendment was complicated and interesting. We did have one more question, and I don't know that there's an answer to it. But the question was, how do we justify locking up thousands of people without due process?
I mean, I think
Do we?
our answer is that we
don't.
don't.
Yeah. I mean, I don't know a way to justify denying due process. So that's me personally. I'm sure that there are people that would argue you an argument, but that would just be my response to that. And I have to say, I'm very proud of Mara and I because we made it in 3 minutes under an hour. It's a small miracle for us because we always have a lot to say, but we look forward to seeing you next month.
Yeah, and if people have more questions, put them in the chat or the Q&A. But while you think, we'll just go over what we've got coming up. On Friday, June 12th, which is just a couple of weeks away, we're going to tackle the 6th, 7th, and 8th Amendments. We're going to skip July and reconvene in August on the 21st to talk about the 9th and 10th Amendments. And you'll understand why I'm chuckling about that in August. And then we're switching things up. Instead of a Friday, we're going to meet on Thursday, September 17th, to sort of wrap everything up, if we can. And the reason that we're switching to Thursday is because September 17th is Constitution Day. It's the anniversary of the day the Constitution came into effect, so we thought that was fitting. So
let's see. Looks like there's one more question. Let's see if I can see that. On behalf of the Cutchogue's New Suffolk Free Library, thank you so much for a Zoom presentation. You're more than welcome.
Very welcome. Thank you for joining us.
This is despite diving deep into the Magna Carta, I'm really enjoying this whole series. So thank you all for joining us. It's really a pleasure. So
yes, and we hope to see you again in June and going forward. And Sarah, did you put the link in? I can't.
Yep, I did at the top.
Okay.
So the link was put in, but I'm also going to send it out in an email that I send to all the libraries and then all of the patrons that joined us tonight that I have email access to.
Wonderful.
So
yeah. So Sarah has put together a YouTube playlist of all of our episodes so far. So if you missed one or you want to go back, click on that link and you'll get all of them, and she'll keep updating them as we go along.
And on a rainy Saturday, you can watch all 5 in a row, right?
Or if you really can't sleep.
Yeah, we really can't
Definitely.
sleep.
Tonight's recording will be ready probably by Monday afternoon next week, just in case anyone's like, I missed the first 5 minutes. I will get it to you as soon as I can. No worries.
Yes,
Thanks,
thank you very much,
everybody.
Sarah. Thanks, everybody.
Okay.
All right.
We'll see you. Have a good
Thank you so
weekend.
much. All right. Have a good
Bye.
weekend.